Hi everyone. So now we are discussing the proposed answers to the mock test 1, paper 2. And before we start, it is very important for you to take note of a few things. One is that your writing should be absolutely clean and clear, and there should be, best way to answer your questions is that you go in a chronology, meaning you start with part A, part B, and then part C. I mean, it is okay to start with part C if you feel more confident, that is fine. But think about examiner, you're actually breaking the loop. Your loop should start from part A, then part B, part C, have a thorough learning of the acts so that you don't have to really choose which one to follow first. Follow a right protocol of following a chronology. Second is beautiful handwriting. Third is the way that you should respond is to start your answer with a fact. Fact refers to the very brief summary of the given situation so that examiner doesn't have to refer back to the question paper. After the fact, immediately give your exact answer, meaning which is the relevant form, which is the relevant fee, if it is yes and no, why yes and no, and then you give an explanation. Okay. Many of you either are not giving facts, your handwritings are too bad, and even if you're establishing facts of the given situation, the fact is quite as big as the question given. So it has to be brief and not more than 2 lines, maximum 3 lines. That is it. And then you people, then after giving facts, you will just keep explaining it such for a long time. So much of text, heavy loaded text in your papers. That should not happen. So your 5 marker should lead to only half a page of answer or 1/4, quarter page answer should be there, or maximum 1 page for a 5 marker. For 10 marker, 1 page answer. That is it. 1 page, a little more than that. Maybe a few more lines, more than a page. तो जितना आप crisp रखेंगे, जितना आप perfect रखेंगे, examiner will be very happy. See, no examiners will read your entire answer sheet. They will just look for the right relevant answer, which is whether you have picked up the right section or not. The moment he sees the right section is written, he will just tick mark and will give you marks. He won't even read your explanation. But you have to give explanation, right, which has to be short and crisp. So idea is कि आप इसको LLB का एग्जाम मत बनाएं, ठीक है, इसको साइंस का एग्जाम बनाएं. Scientists or scientific students, engineering students, technical students, they don't write a lot of stuff. You're not writing your PhD thesis here. You're writing just the government exam. So when you write an exam, you have to understand mentality of the examiner also. Anyway, cutting the long story short, let's get into the answers. Question number 1. Write short note on exceptions to the infringement under Patents Act 1970. Identify and explain all the relevant sections. So all relevant sections are section 47, section 49, section 99, 100, and 101. Then 107 A, and both the provisions of this 107A. So these are the ones that you would say that you will present the fact of the case, exceptions to infringement, following are the relevant sections, and then explain each section in not more than 2 to 3 lines. Second number question is, consider a situation in which Rockwell is an inventor who is a citizen of country A but resides in country B. Neither country A nor country B is a member of Paris or TRIPS Convention. Rockwell has recently invented a medical device for improving ECG signals. He is over-enthusiastic about his invention and overestimates the commercial potential of his invention. He wishes to obtain patent protection for his invention in 40 countries, one of it being India. So the catch here is very clear. 40 countries and one being India, including country A and B. तो आंसर करना है आपको 3 सबसेट क्वेश्चंस को. फर्स्ट क्वेश्चन इज पार्ट ए. Explain Rockwell about the strategy for filing applications in 40 countries, including country A and B. Could a PCT application be filed? If yes, then how? Very easy. It's 40 countries. Certainly, convention will not work. Convention application won't work. You will have to mention about PCT is the right route to follow when it comes to 40 countries. Since India is one of the potential countries for seeking protection, so designate India. File first in India. Take priority of Indian application. File a PCT. Designate India to come back to India in 31 months. That's it. You want to give a PCT route? in the form of a graph, it's fine. But that's not required for a 5-marker really. Don't waste your time. If you have more time, then maybe you draw it. And then, so India filing followed by PCT filing taking India priority. And also when you file a PCT, simultaneously on the same day, file in country A and B as well. Because those two countries have to follow a separate route because they are not part of PCT. Part B, Rockwell is interested in obtaining patents in 40 countries. However, this is costly endeavor because of both official fee for filing, re-examination, renewal fee, and so many other things are there. As an experienced patent agent, what would be your suggestion for Williamson or Rockwell regarding the factors that they should be considering to narrow down the countries? So basically 40 countries are applicable when you have a PCT route, but even PCT is not easy to file. It's quite expensive. And plus when it comes to English filing, because document may be in some other country language, then it becomes even more expensive. So they are asking how would you help your clients to narrow down the list of countries? So बहुत easy है. It is completely a business strategy. In the business strategy, whether it's an offensive filing or a defensive filing has to be as per the business wish list. So what all are the factors you will look at? That which all are the countries where there is a huge market base? What all are the countries where there is a potential or purchasing power parity of the country over there? And then similarly, you will find where are the potential licensing that could happen. So these are the key factors that any business would look at. Fourth, you would look at the countries where compliance and regulatory framework is not as intensive, right? So these 4 factors you'll put, and any more factors that you want to include, please include. Now part C, Rockwell eventually managed to obtain a patent in country B. He is excited and confident to get his patent in other countries also. By producing granted patent of country B as a convincing evidence of patentability in other countries. Is it correct? Explain suitable sections and relevant rules with respect to India. So of course, we've already understood that one country grant cannot influence the grant of the same invention in other countries. Every country follows their own patent law, and there are quite a lot of distinctions between different patent laws of different countries. Hence, one country grant cannot influence the grant in other countries. However, grant in one country can certainly become a benchmark for the other countries to follow in terms of the prior art searches that that country took, so that there is a sharing of knowledge, so that grant in the other countries could be expedited, but it cannot be influenced. That part you have to clarify fully. Okay, that's the answer. Then question number 3, Dr. Ashok Kumar is a CSO of a leading Switzerland-based biotech company, Goldmine AG. Dr. Kumar invented a new class of semi-synthetic penicillin that proved to be very valuable antibiotic. Dr. Kumar approaches you to draft an application. As a patent agent, what steps will you evaluate for patentability? तो देखो ये जो patentability है, and this is regarding the biotech invention, which includes semi-synthetic penicillin. मतलब क्या हुआ? Semi-synthetic मतलब it has usage of some biological resource or some biomaterial or microorganism. So therefore, section 10.4 becomes exceptionally important. The information about National Biodiversity Authority, the permission is to be required from them for benefit sharing. Plus, you will mention about the depository, international depository institution, where you will have to supply this biomaterial to get the relevant numbering. So these are the important steps that you will help him. Plus patentability would also include, besides this, section 10.4, it will be section 3E. Also, I think, yeah, so section 3E is the most relevant for this particular one. Many of you have picked up section 3D. I don't know why. It has absolutely no linkage here. Look at section 3I maybe also. You can refer to that section very quickly. So yeah, that would be the answer. Relevant rules, fee form. So whatever comes to your mind, for example, relevant form for taking permission from National Biodiversity Authority would be applicable. Then the taking information from the International Depository Institution Authority, that also you would need. You can mention about the sections of non-patentability from section 3 So yeah, that would be the relevant answer. Question number 4. Dr. Kumar's invention as described above, what consideration will you make or what kind of information would you require to draft different sections of the patent application? So what are the different sections? Different sections are summary of invention, prior art, which is the background of invention. You also need detailed description, which includes best mode of making your invention or synthesizing your invention. So in this, you will take information about all the relevant prior art searches that have been carried out by the client. You will need information about foreign filing status, which is section 8. You will also need information about the detailed description, which is what is the relevant problem in the art which scientist has tried to resolve in a technical way. You will also take information about how to overcome the issues of section 3E, which is how the experimental data basically to establish or overcome the synergistic issues that are mentioned as a threshold under section 3E. Next situation given is Dr. Rajesh is there, who is an inventor in Finland, in a silverwood company. He invented a super powered hydraulic machine, very valuable for the industry. He is prosecuting his application in various countries. Company Goldmine came to know about it, and he needs your advice, which is you as a patent agent. When they came to know about his highly useful invention and aims to commercialize his invention in India, France, Germany, and US. The question क्या है? Based on the above situation, what steps, part A, what steps will you take to evaluate patent litigation risk associated with commercialization of machine by Goldmine? So here in part A, there is no litigation risk because the application is not yet filed even. Here, Dr. Khanna is only thinking about filing a patent application in other countries. There is no application yet filed. Your infringement risk, litigation risks initiate only after the grant of a patent. So you could mention that there is no litigation risk, Goldmine can go ahead. However, Goldmine has to be aware that if in case application is already filed by Dr. Khanna and he can prove a prior priority, then after the grant, he will be liable to pay damages or accounts of profits upon the grant of a patent from the day of publication of such application. In fact, litigation risk, I would say, is not there at all as far as this is concerned, because once Goldmine starts to commercialize his invention, his own commercialization would become a prior art, maybe against Silverwood. Of course, Silverwood would have to then prove, no, he is the first one to have invented it. So basically, the answer is that no litigation risk right now, but there would be a risk in case application which Silverwood is trying to file gets granted. Then point number B is, will your advice change if Goldmine in case your evaluation concludes that Silverwood has been able to secure a granted patent in US? So here, of course, Goldmine would have to be careful about any commercialization in US because there is already a granted patent. But as far as India and Germany and France are concerned, you will give an advice that we will have to check the records of the respective patent offices if the patent application has been filed in these countries already. If yes, then if he goes ahead with commercializing in these three countries, which is India, France, and Germany, then after the grant of patent, he'll be liable to pay profit of account and the damages. Third, and in fact, for point number B, we ask him to also take a license. If he takes a license from US, ask him to take a worldwide one global license so that he doesn't have to, he has a freedom of working or he has a freedom to operate in all other countries as well, no matter whether it's in an application stage or a granted stage. Third number, will your advice change if you find that Silverwood has got the patent granted in India? So the same situation that I described to you for B, here you will say that in India he can seek a license, which is a global license, to market in other countries also besides India. D, your evaluation concludes that Silverwood has been able to secure patent in India but not in US. USPTO rejected it on the grounds of non-patentability. Will your advice to Goldmine change if he sells the invention in India by importing it from US? So the answer is that this provides him with a very important opportunity to oppose the granted patent in India basis the rejection that has happened in USA. So that even if it has been frivolously granted in India, you can tell to patent office by filing a post-grant opposition or by filing a revocation if it's beyond 1 year that patent has been granted, that you will tell Goldmine to rather oppose the application in India. Question number 6, based on the above situation, will your advice change if commercialization of the product takes place after Goldmine obtains his own patent over the invention in India and US? So in this, you will say that since Goldmine has ownership rights, has patent rights already granted by 2 jurisdictions, it is absolutely exclusive right that Goldmine has to commercialize it, and they can go ahead. However, you have to tell him, you have to raise a red flag that Silverwood may try to oppose Goldmine's granted patent, basis that Dr. Khanna was the first one, or Silverwood was the first one to have invented it, and wherein they can show a prior priority date as against yours. Point number B, what will be your advice if Silverwood imports the invention in India from US when Goldmine has his patent already granted in India? So here Silverwood is wanting to bring the invention in India because by importing it from US, because US doesn't have a granted right of Goldmine. So here Silverwood is allowed to do so by doing a parallel importation under section 107A B, because that allows to pick up the patented invention from the authorized dealer in other country and bring it in India. So that much is allowed, and you have to tell Goldmine that this parallel importation is a opportunity that is available to the importer here. Point number, but then advice has to be still to Goldmine, because this section 107A is not in best interest of Goldmine, right? So then you will also tell Goldmine to also try to seek protection in US. But in point number A, that has been already made clear that in US it has been rejected. So finally, you will have to tell Goldmine that although the opportunity exists for the importer, section 107AB he can utilize, Silverwood can utilize. So there is nothing much that Goldmine can do if that importation happens. But what can Goldmine then do? Is to proactively reach out to Silverwood for a potential license. Because whoever has come to seek your advice, besides showing him the relevant provisions in the act, you have to give him the answer also that can benefit him at the end of the day. That is how as a patent agent you'll be able to do justice. Point number C to question number 6. It is discovered that competitor of Goldmine, that is Goldfire, has a patent on the same product in US. Would your advice change? So this is quite a tricky question, because here Goldmine has the rights in India while it got rejected in US, but some other country got it in US. So here you will tell Goldmine to file a opposition to the Goldfire's patent on the same grounds as it has been raised for rejection of his patent, his invention, for which it got rejected by the USPTO. So if it got rejected to Goldmine, how can Goldfire have it in US for the same invention? Next question, question number 7. Catherine from country Z is the inventor of an improved solar panel. Catherine exhibited her invention in a private exhibition held in country Z. Catherine is interested in applying for a patent in India. She has come to seek your advice. Point number A, or subset question number A is Catherine wishes to submit her application in India before July 2023. है ना, क्योंकि अगस्त में किया है, तो she has 2022, so she has 1 year to still file in India from the day she presented. What would be your advice? So your advice is you go to section 32 and find out the relevant section in the exceptions to the anticipation, and say that if it is exhibited in private exhibition, or it doesn't have government, it's not a government notified exhibition, then already it becomes a prior art. She has lost the chance to utilize the grace period which is provided under the Indian Patent Act. So she can't even file Form 31. Point number B of question number 7. Assume that Catherine filed an application in India and also got a grant. After paying the renewal fee, she forgot to pay the maintenance fee. So basically, her patent has been lapsed because her son was unwell and he was in the ICU. So it's very easy. All of you have given your correct answers, which is your bringing your patent back to the life by going for a restoration of lapsed patent, and you give the relevant section, form, and fees.